Hear ye, hear ye. Now, Chief Justice of the State of Michigan. All persons having business with the son of a court are admonished to draw nigh and give their attention to the court is now sitting. God save the United States, the State of Michigan, and this honorable court. Good morning and welcome to our December and last oral arguments of this calendar year. For those of you advocates who are not frequent flyers with us, let me go over a few of the rules. First, for calendar cases, each side is allocated 30 minutes. For the MOAs, each side is allocated 15 minutes. We provide you uninterrupted time at the beginning of your arguments so that you can explain to us the outcome determinative issues. And I encourage all advocates to get right to those, avoid the throat clearing. We've read your briefs, so don't waste a lot of time doing unnecessary things that don't help us understand what you think causes us to consider the case in your favor. If you wish to reserve time, you must so indicate, but you have to manage your time. I do not promise. I'll tell you when your reserved time is up, but I can't promise you that you'll be able to do it. And with that, I will call the first case, Lowery versus Enbridge.
Good morning, Your Honors. Kathleen Lang, appearing on behalf of the appellants, the Enbridge entities. I would like to reserve 5 minutes of my time for rebuttal. In granting leave to appeal, this court instructed the parties to answer 2 questions. Number 1, was plaintiff required to present expert witness testimony to establish causation? And number 2, whether the plaintiff in this case sufficiently established causation to avoid summary disposition. Respectfully, Enbridge would answer that yes, plaintiff is required to present expert witness testimony to establish causation, and the evidence presented in this case was woefully insufficient to establish causation. In every other area of law in Michigan, when there are complex questions of causation that are beyond the understanding of a lay jury, this court has concluded that expert testimony is required. Toxic tort cases such as this one are no different, and the rules should be no different. However, the lower courts have used the holding in Jenna versus Jackson to reach an opposite conclusion, namely that expert testimony is not required to prove causation in toxic tort cases. Jenna was a unique and very specific set of facts in which plaintiffs actually did have experts who testified there was a massively high level of mold, that the level of mold was toxic and could cause human health reactions. The children in the home were healthy before the mold was discovered, they were sick while in the home, and they recovered when removed from the home. The Jenna court declined to adopt a rule that expert testimony was required under the circumstances. In that case, to prove a specific causal link between the toxic levels of mold and the children's illness. But in declining to adopt a rule, Jenna has allowed litigants and the lower courts to excuse toxic tort plaintiffs from needing expert testimony on causation, even when the causation involves scientific, technical, or other specialized inquiry. This court should now establish a rule that expert testimony is required in a toxic tort case when the issue of causation involves scientific and technical matters. Specifically, the rule should be that in toxic tort cases, plaintiffs must prove both general and specific causation, and that expert testimony is necessary to establish both. In contrast to Jenna, the need for expert testimony is particularly important in the facts presented in this case. Here, there was a release of crude oil into a vacant field that ultimately migrated into the Kalamazoo River. It traveled more than 35 miles downstream in the Kalamazoo River. As the crude oil traveled, VOCs, volatile organic compounds, were released into the air. Some of the VOCs had the potential to impact human health if there was exposure in a sufficient dose for a sufficient period of time. The plaintiff, Chance Lowery, lived more than 10 miles from the release site. He claimed that he was exposed to VOCs more than 3 weeks after the release and a week after he claimed that the odor from the release had dissipated. His claim is that the VOCs caused him to vomit so severely that it resulted in a tear of his gastric artery. To support this claim, he relied on an expert, Dr. Jerry Nosenchuk. Dr. Nosenchuk is a DO. He admitted he was a family physician. He had no training in toxicology or vascular medicine. He did not treat Mr. Lowery. He did not examine him. He did not even talk to him. His opinion initially was based on a review of selected medical records, a newspaper article regarding the oil spill, the plaintiff's deposition transcript and answers to interrogatories, and a few photos of Mr. Lowery's property, as well as a report from the State Community Health Department that was ruled inadmissible. He did not review any article, study, or scientific material when he initially gave his report. At his deposition, he had reviewed a couple of documents he found online about crude oil and abstracts of 2 articles that he found on the internet regarding gastric tears. He had no idea the levels of VOC exposure necessary to cause the type of symptoms Mr. Lowery claims to have experienced. He didn't know what level Mr. Lowery was actually exposed to, and he had no idea of the chemicals that were present in the oil release. And more importantly, he didn't review the thousands of air monitoring and air sampling results that were publicly available, which would have evidenced if there were VOCs present, at what levels, and in what locations. Instead, Dr. Nosenchuk simply assumed the fumes must have caused the symptoms. And he summed it up himself in his own testimony when asked about the basis for his opinions, and I quote, "There was an oil spill, there were significant fumes, and people got sick. That's what I relied on."
Counsel?
Your Honor.
This isn't a case where there was no expert testimony. This fellow, the general practitioner, actually testified. You're challenging the competence. And
we're challenging both the qualifications and the reliability of his testimony in this case. But
there was no Daubert hearing, was there?
There was not a Daubert hearing, although we raised the issues in our motion for summary disposition that he was not qualified to offer any opinions. The Court of Appeals in this case never reached that issue because they concluded there was no need for expert testimony here.
Well, there was expert testimony. That's the problem I'm having. Just as in the mold case, there was expert testimony. The question is what the component parts of that expert testimony must be in a toxic tort case.
Well, I think there are 2 issues, respectfully, Your Honor. One, there was a person who purported to be an expert that gave testimony. But as I just went through his qualifications, he had no qualifications, he had no basis to really give the testimony. You know, in the end of his deposition, he said, "I'm a simple guy. Spill, fumes, sick people, to me they're all related."
He wasn't a toxicologist.
He wasn't a vascular surgeon. He had never seen a gastric tear.
What the etiology of this, what the gastric tear was. I understand all that. That goes to something about the quality of his testimony and its reliability. Those are things that are usually addressed in a Daubert hearing, aren't they?
Well, as the Seventh Circuit has held, a Daubert hearing is not always necessary. The trial courts need to be given flexibility as to how to handle Daubert issues. This court has allowed Daubert questions on the reliability of expert testimony to occur based on the briefing. Amaretto was one of those cases where the court indicated that just because you have an expert, it's not enough to get to the jury. The expert testimony has to be admissible, and there was no Daubert hearing in that case. So I don't think a Daubert hearing is necessary when on the face of the evidence, the qualifications aren't there and the opinion is not reliable.
Counsel, I'm sorry. So I think I might have missed this in the record. It wasn't clear to me that you raised reliability of this particular expert in the trial court.
We did in our motion for summary disposition and in the reply brief.
Okay, so it was one of the grounds that you asked the court for a ruling, because the trial court did not rule on that.
Correct.
Trial court did not find for you on that, but we can infer that he found against you, I guess?
I think the trial court came to the right conclusion. He ruled that there was no causal link. He didn't say it that way, but he said
there was no specific ruling on reliability, which was one of the first things that struck me was and I thought it was because it wasn't raised.
No.
You're telling me it was.
It
So-
was raised, and I
Okay.
can give you the sites in the appendix, but we challenged
find it.
both on 702 and on statutory grounds Dr. Nosenchuk's ability to be able to issue opinions in this case.
Okay.
Can you help me understand where I need to be focused in this case? Number one, we know that harmful amounts of VOCs were in the air near the river by plaintiff's home following the spill based upon EPA data. One, it seems to me, might reasonably argue from that fact that the average juror, uninformed by expert evidence, would understand that toxic fumes in the air can cause a person to cough and vomit. Secondly, plaintiff's expert, Mr. Nosenchuk, Dr. Nosenchuk, testified regarding medical literature that established that vomiting can cause a gastric artery sometimes to avulse off of the spleen. Why are those two facts together not sufficient, at least to survive summary judgment?
Let me address them in the order you raised them, Justice Markman. First of all, we don't know that there were toxic levels of VOC fumes near Chance Lowery's house. That's the whole point. Nobody ever looked on the plaintiff's side at the evidence to say, were there any VOCs, what level were they at, and how was he exposed?
But counsel, weren't people that were surveying it wearing hazmat protective gear?
There were the workers that were working on the actual remediation in the river wearing hazmat suits, yes. But their exposure was considerably different than residents outside the river and far away from the release site. In fact, the community health departments declined to issue any sort of evacuation notice anywhere near where Mr. Lowery was. There never was a mandatory evacuation, only a voluntary evacuation for the homes right near the release site.
First, I just want to make sure you've answered Justice
yeah.
Markman's question. There is no evidence about the level of VOCs in the vicinity of the plaintiff's home.
In this record, there is not.
Okay.
Is there evidence of VOCs in the air sufficient to allow an ordinary juror to conclude that coughing and vomiting might be a likely outcome of that? Or
No, yeah, there's simply no evidence of any
anywhere?
readings of VOCs.
It's not just that he was 10 miles away, it's that there was no evidence at all of that.
There was no evidence either of air sampling, air monitoring, or any kind of what the VOC level was near his house.
Would Appellee's counsel disagree with you as to that proposition?
I don't think so. I don't know what they would base it on if they did.
Is it within the competence of a layperson to determine what kind of physiologic activity would cause a rupture of a stomach artery?
I think that was going to the second part of what I was going to get to in Justice Markman's question. I believe the answer is no. Dr. Nosenchuk admitted he's not a surgeon. He's never seen this condition before. The sum total of his knowledge came from looking on the internet at 5 or 6 abstracts of articles, of which he said he understood 2, and he downloaded those 2 abstracts, and that was the basis for his opinion. He didn't even download the articles, just the abstracts. And we've attached the abstracts to our brief, and if the court has a chance to look at them, what they simply say is this is a very rare condition. It has a number of causes, and emergency room physicians should be on the lookout for it. But it's certainly not a matter that a lay jury, if you walked up to a person on the street and said, can vomiting cause a gastric tear artery, would have the knowledge to know.
So we already have a rule that says that if a matter is outside of the ken of an average person, a layman, that expert testimony would be required. So I'm just wondering, do you think we need some special rule for toxic tort cases, or will our ordinary evidence rules handle this?
I think the court needs to very specifically instruct the court that toxic torts are within that rule. Because based on Jenna and the gas case out of Sixth Circuit, the lower courts have said toxic tort must be different than other cases. We can infer more based on Jenna and gas. And I do not believe that's what the Jenna and gas cases stand for.
I read Jenna and don't even follow why that's what. What are the? Give me some examples of where this has gone off the rails.
Well, I think the Court of Appeals is a perfect example.
Your case is one.
Yep.
It might be one. I'm not. But yeah. But are there? Can you tell me about some others that that would be a good answer to Justice Larson to say you guys really need to double down and do something here because there are all these cases and they're going sideways and.
I will say, Justice McCormick, I know it from the trial court level, that the
Okay.
trial court judges tend to latch onto Jenna and say, and they read it very simply. Jenna said we don't need a rule that expert testimony is required, therefore we can infer it based on correlation, which is what happened here.
Right, so it's,
So just reaffirming
the evidence rules
the
apply.
basic premise that when we're dealing with scientific matters that most of us have no expertise in, you need expert testimony,
That's-
like physicians and malpractice.
That's correct, and reaffirming that toxic tort cases are not an exception to the rule generally in Michigan.
Well, you're asking for a great deal more than that, aren't you? I mean, I think one of the amici suggested that would be a great clarifying thing to say, this is part of the same generic species of cases that require expertise. You're talking, I think, about the necessity for us to adopt the general specific causation test. Why is that?
Well, and I actually don't think the appellee disagrees with that. I think it's on page 15 of their brief. They say the plaintiff is required to prove both general and specific causation. So they agree with that for us. It's just a simple way of breaking down the causation in a toxic tort case. You have to be
This is a unique test for only toxic tort cases?
I think the way it has been framed by courts throughout the country, you have to be able to show that the toxin is capable of causing whatever the symptom or injury might be, and you have to show that the plaintiff was exposed in sufficient amount to have that occur. They call it general and specific causation. I suppose it could all be rolled into cause and fact.
It sort of feels to me like, yeah, every tort case, you have to it has to both be the case that if I hit you with my car, in general, it might injure you, and that actually I injured you when I hit you with my car. I mean, in some ways, that feels not that controversial to me. Like, what tort plaintiff doesn't have to show both that generally this injury could result, and it sure did?
And I think the reason, and I would hate to speak for the courts from around the country as to why they characterize it this way, but I think in part the reason is we don't live in the Garden of Eden. We're all exposed to toxins every single day. Mr. Lowery, as a smoker, was exposed to benzene constantly. So the courts look at it and say, first you have to look at the toxin itself and say, is it capable?
Yeah.
Is it likely? It's not like the car hitting where it's obvious. Some toxins will be capable of producing symptoms, some won't, and it's very dependent on the dose.
So, counsel, I'd like to give you a hypothetical, really just based off of what you just said. Some things are obvious. So let's kind of focus on that for a second. My hypothetical is this. Let's say you have a young child. Child is pretty much healthy. They've consumed water that has lead in it for quite a period of time.
Just to make it topical.
So let's go back. You have a young child. They're healthy. They have consumed water that has high amounts of lead in it. Would you concede then that that is relatively straightforward, and that in that circumstance it's more likely than not that the lead in the water is what induced the injury to that child? And then would you further concede that the circumstantial evidence is enough in terms of the fact that the child consumed the lead water, that is what induced the injuries to that child?
Initially, Your Honor, I would not concede that it is within a lay person's purview to determine that a child that ingested water that had some level of lead in it was, that causation could be established through lay testimony. I think that, again, involves scientific and technical matters. How much was the lead? What was the injury? What was the child's condition before?
So really, for all intents and purposes, I mean, because this case is really going to be a precursor for other cases, so that's really what your position would ultimately be, that you need to go and that there's really no room for common sense, that a jury isn't able to determine the causation in that situation.
I don't think it's a matter of common sense, Your Honor. One of the amici brief had the example of, is somebody downed a bottle of bleach? Could a jury determine that downing bleach, which has a warning on it, which is within the common understanding of human beings that if you drink bleach, there's going to be an injury, do you need an expert testimony for that? Maybe not. But I think lead at unknown levels in water is not the same situation.
But I think that point is implicit in Justice Bernstein's question. Do we always need expert testimony, or are there circumstances, maybe not in this case, but are there ever circumstances in which we don't? We require, you liken it to medical malpractice cases. We require expert testimony there largely as a function of the fact that our state medical malpractice laws require such expert testimony. It's not that we've never ever seen a medical malpractice case in which the jury has it within its capabilities to make these kinds of determinations. So I understand the question in part to be, can there ever be a circumstance in which by either consuming bleach or something along those lines, the necessity of an expert can be dispensed with?
I think the rule needs to be that, as it is in every other area, that expert testimony is required because these are technical, scientific inquiries.
Do we
It is then,
Excuse me.
Unless they're not, that's the question.
Do we need,
I was just-
for example, when you have an instrument or a sponge left in a patient after surgery, do we really need and the repercussions are infection from the instrument left in the patient. Do we really need expert testimony on that?
no, and I think that this court has held that there are certain acts that can be an exception to the rule.
Well, that's...
My point is that I think there needs to be a rule.
Counsel?
Oh, sorry, Your Honor.
I think you're being challenged to acknowledge the sky is blue. In general, when there are significant scientific questions, you need expert testimony. But on those occasions that you don't, you don't.
And that's,
You can't acknowledge that?
no, that's what I was going to get to.
Oh, okay, I'm sorry for interrupting you for going in the right direction.
What I was going to answer to Justice Markman was, I think the rule needs to be that you need scientific, or you need expert testimony. I think it's incumbent upon the litigants to tell the court why that rule is not appropriate in a particular given case. Just as in medical malpractice, where leaving a sponge in someone, this court has decided you don't need expert testimony to say that's malpractice.
Well, you might if the injury is idiosyncratic. If it isn't an infection, but, you know, a cerebral hemorrhage, you might actually need testimony to explain how a sponge left in the patient after surgery caused a cerebral accident.
Correct, Your Honor, but you wouldn't need expert testimony on whether leaving a sponge in somebody was malpractice.
Right. But the injury could, that could present, just as drinking lead, if the injury is chicken pox, you'd have to explain scientifically why drinking leaded water led to the injury.
Well, so I'm still confused about, I'm back to where Justice Larson was. Why isn't the rule we have good enough? I mean, we already have this rule that requires when the question is technical and scientific, we need expert testimony to be able to explain it to a jury. Why doesn't a plaintiff just proceed at her own peril if she goes forward without an expert and it's a lead case, or where there might be some questions, or a case where an expert hasn't said that rupture results from vomiting, or what? I mean, why isn't it good enough, the rule we have?
Because I think what happened in the Court of Appeals here is exactly why this court needs to clarify to the lower courts what the rule is. Here, not only did the trial court, based on pure correlation, he lived in the vicinity, and he smelled fumes, therefore the fumes must have caused his injury. They went a step farther and said, and he had vomiting, and the vomiting caused the tear in the gastric artery.
It's a lot of steps.
It's a lot of steps based on no evidence.
Right.
So you just want us to say, if we were to write an opinion, what your version of the opinion would be to say, don't read Jenna to say that correlation equals causation. You need to adhere to the normal rule that you need an expert when you need an expert, when it's beyond an average layman's understanding.
Correct,
That's
Your Honor.
all you want us to do.
That is correct. Now, if the court wants to go further and talk about the qualifications of Dr. Nosenchuk and why a family doctor can't give the opinions he gives, I would be fine with that. But the rule that I think is important for the lower courts and for litigants is toxic tort cases by their nature are no different than the other rules that this court has promulgated.
Would we have to conclude that Jenna's wrongly decided, or is there some ground in which we could distinguish Jenna and you could prevail?
I've spent a lot of time thinking about that question, Justice Zara, because Jenna is so integral in this case. I don't think this court has to decide that Jenna is wrong or has to overrule Jenna. I think Jenna was based on a very set of specific facts where there was expert testimony on general causation, just not on specific causation. And in that case, the court found that the logical flow of events, the children weren't sick before, they were only sick when in the condominium, they recovered when outside of the
Isn't that
condominium.
simply correlation?
On the specific causation
Yeah.
it was.
That's sufficient, then.
In that set of facts, the court determined it was sufficient,
Is
which
that-
goes, oh,
I'm just saying, in general terms, we say correlation is insufficient basis for a causation, isn't it?
but that is correct, and that's the ruling in Craig. But what the court in Jenna did,
Well, I like Craig.
I like Craig too.
So, being faithful to Craig, how is Jenna sustainable?
As I said, I struggle with Jenna because there's a part of me that thinks Jenna and Gass were wrongly decided under the principles of this court. But I do think because of the unique...
So we should cast a little shade on it, maybe?
But I do think under the facts of Jenna, you had an expert who testified there were toxic levels of mold. That mold was capable of causing the type of injury that the children had.
General.
General
It's
causation.
the specific. It's the explanation of the etiology of the children's illness that is missing.
That's correct.
All that is there is, this happened, they got sick, they left, they got better. That's not a diagnosis of whether their exposure caused their illness. It's just timing.
Correct.
It might be suggestive, but the causation requires some evidence, doesn't it, of more than temporal relationships. It requires an actual showing of the causation link there, right?
Absolutely, Your Honor.
That's missing in Jenna.
Well, in Jenna, what the Court of Appeals said is they thought through circumstantial evidence that link was present, even though there was no expert evidence on that issue.
There's so many occasions when people make associations that we have concerns. You're into your reserved time. I just don't understand why you're conceding this point.
Well, because I do think Jenna, I do think there are times when circumstantial evidence under specific facts may be able to be used in lieu of expert testimony.
Okay, if you want to reserve, you better sit down.
Thank you, Your Honors.
Good morning, Your Honors. May it please the Court, Nadia Hamadi on behalf of the plaintiff appellee in this case, Chance Lowery. Your Honors, I would like to reserve
You don't have, you're the...
I
not the
apologize.
appellant.
We'll go straight through.
You go all the way through.
Or you can just stop if you feel like it.
Yeah, you don't have to take your 30 minutes if you don't need to.
Okay. We all know the noxious odor that emanates from fresh laid tar when paving crews are out paving the street. The average juror would know this noxious odor. Now imagine that putrid smell surrounding your home for over 3 weeks straight. Now, I would agree with Judge Jansen's analysis in her dissenting opinion that there is a two-step causation here, that the plaintiff had to establish first that exposure to the Enbridge oil spill caused the nausea, coughing, and vomiting. And I would state that we have that here. There is testimony from neighbors about the horrific smell in the area at the time of Lowery's injury, from Lowery himself, from Ashley Green, his girlfriend, from several other witnesses. Also, there were other cases contemporaneously with this case that were referred to by the judge, the circuit court judge in Calhoun County. He said that he's heard plenty of testimony about how the smell of the oil has caused the same type of symptoms for plenty of the neighbors. And so there is some collateral estoppel there for the defendant about their claims that the fumes, that there was insufficient evidence to establish that the fumes from the oil spill caused Lowery's vomiting, nausea, and coughing spill. And then the second analysis that Judge Jansen set up is that the plaintiff has to establish a link between the nausea and vomiting and the tear of the gastric artery. In this case, we did have expert testimony from both the surgeon who performed the surgery, Dr. Koziarski, and from Dr. Nosenchuk. Dr. Koziarski said that this type of injury typically results from trauma. What is the trauma here? We have testimony from Dr. Nosenchuk, who would be qualified to say that that vomiting would cause a violent displacement. And I'm quoting from his deposition testimony. Basically what happens is with the cough and vomiting, there's a violent displacement of intra-abdominal organs, specifically the spleen, because the short gastric artery is attached. This is sufficient testimony to create that causal link between the coughing and the vomiting and the tear of the gastric artery. Now, I believe what the court is looking for is what is the rule? What component does the expert testimony play in a toxic tort case? Here, we have the evidence that creates this, it would be circumstantial evidence that would lead to a reasonable inference of causation. And we believe that the rule should be that where there is sufficient evidence, and we believe we have that, to circumstantial evidence, that a jury may use their layperson understanding to come to a conclusion of causation. Now, for every action, there is a reaction. But every reaction is different for different people, so we have to look at the specifics of this case. In this case, we're not talking about exposure to toxic VOCs over a long period of time that leads to some chronic illness. Here, we are talking about a traumatic injury that resulted from coughing and vomiting that was caused by the exposure to the smell, the horrific smell of the Enbridge oil spill.
Counsel, I guess I'm just having difficulty understanding how a lay juror, without having somebody testify, an expert, that the etiology of the gastric artery tear, rupture, can be caused in the manner alleged by you, and that it follows, that there's a linkage. For example, I assume if there had been other gastric tears for the neighbors who were equally exposed, you would have brought that to bear. It strikes me that your client had a very unique reaction if this was caused by the exposure. So the question is, what were the other possible reasons for this tear? Your expert couldn't and didn't consider, or he said, just it's my experience that I'm saying it couldn't have been anything else. He didn't have very much to say about whether this injury was related, caused by the alleged exposure. Why isn't that a very significant gap that can't be filled simply by saying, well, there was exposure, he had this rupture in his gastric artery, Bob's your uncle?
Now, a layperson would have the understanding of the pushing, the pulling, the strong force of vomiting and coughing in the abdominal cavity. A layperson would have experienced vomiting at some point in their life. Most lay people, I'm sure that you can
especially in the teenage years.
Especially. And so they would have this understanding of the strong force of that the vomiting causes in their abdominal cavity.
I know, but most of us don't experience an arterial tear in our gastric artery.
That's true, but
Isn't
when
that
you have
the problem
this,
here? It's an unusual reaction that needs explanation?
it is a very unusual reaction, but we have the testimony of Dr. Koziarski, the surgeon who performed the surgery, although he declined to opine as to the cause of the injury, he did say it's typically caused by trauma.
Problem? He declined to testify about the causes, the etiology. Isn't that the critical problem with your case right now?
Well, he did state that the injury can be caused by trauma.
But it can also be caused by other things. That's the problem. And he couldn't say, he couldn't and didn't eliminate all the other possible causes of the rupture.
Not only did he not eliminate other possible causes, but I think he introduced 2 scholarly articles in support of his position that vomiting was a potential cause of gastric artery avulsion. But both those articles indicated that it was a rare cause of gastric artery avulsion. There were other causes. There were other kinds of things that could create the same kind of phenomenon that he suffered from as a function of vomiting. So I guess I'd like to underscore my colleague's question that it's possible that the fourth requirement of establishing a toxic court case, that there be the reasonable elimination of other potential causes of harm, hasn't been fully satisfied here.
We don't have any proffered other potential causes.
No, I think you're turning the test on its head. I get to offer one, and then the other side has to disprove or offer alternatives. Your burden is to say this is the most probable reason for the injury, not that you throw up one and then you get to bat down alternatives. Isn't that true? Isn't that your burden?
It would be our burden to establish the causal link.
Okay.
And
well, if your witness, as you've just acknowledged, didn't eliminate other medically reasonable causes for the condition your client suffered, why isn't that a real problem for you?
Well, it's not a problem because we have the testimony of 2 witnesses. We have Dr. Koziarski's testimony. He declined to give a causal explanation. Well, he didn't review the medical history of Chance Lowery, so he wouldn't even have been able to get to that. However, we do have Dr. Nosenchuk's testimony.
And what did he say specifically about the not only the etiology, but the probability of other causes being insufficient or not as predominant?
He did review the medical records of Chance Lowery, including the records that were introduced in defendant's brief on appeal, where they discuss that the potential could have been related to the Vicodin because he took Vicodin and he threw up. But Chance Lowery had taken Vicodin on several prior occasions. He testified to that, and he never experienced vomiting. He experienced vomiting on this particular occasion when he was experiencing a very severe headache, a headache being linked to exposure to the toxic fumes. And again, we have other neighbors in the area who experienced similar symptoms, the headache, the nausea, the vomiting, and I believe that the trial court did get that right, that we have the link to show that there was causation between exposure to the oil spill and the headaches, the nausea, the vomiting. So when we're getting at the vomiting being linked to the tear of the gastric artery, this tear of the gastric artery is very rare altogether. Mm-hmm. So what...
but again, I'm not sure you're expert, other than saying it's my experience. I don't think he went didn't really explore what other medical causes might have caused the injury.
There was nothing else in the medical history that would have led him to believe that there was any other cause of the tear of the short gastric artery other than the violent upheaval of the stomach muscle, other than the tearing, this pulling pressure and this displacement. And a layperson would understand if you have this 3-week bout of vomiting, nausea, coughing, this is dry heaves, you got this constant pulling. A layperson would understand you continue pulling on a string and it's eventually going to snap. And you have this.
Sorry, I'm not very convinced about what lay people understand about medical conditions.
Well, I'm not saying that a layperson would necessarily understand a medical condition, but as explained by.
Or what causes them. We all have lots of magical thinking about why we have illnesses that have nothing to do with the scientific underlay of those illnesses.
Well, that's true, but we do have circumstantial evidence here, and that would be the explanation of Dr. Nosenchuk.
Couldn't a jury see that it was, from a lay perspective, wouldn't it be fair to say that they could see that it was more likely that because of the induced vomiting, because of the violent heaves, because of all these things, that it was more likely that it was caused by the vomiting, which was induced by the VOCs?
Justice Bernstein, I think you're right, and I think that's what I was trying to get at is that.
So we don't need an expert at all?
Well.
Isn't that your position then? If a jury can say he was exposed to these fumes, we assume that they caused his vomiting, and we assume then the vomiting caused the arterial tear, we don't need an expert.
Well, I think that we don't need an expert to directly testify on the causal link, but expert testimony can be used and has been used to create reasonable inferences of causation. And it's where there's this violent vomiting spell, this ongoing vomiting spell, nothing else in the medical record that would indicate any other cause for the avulsion of the gastric artery, then we have sufficient evidence. If you go back and look at Skinner, which Skinner creates, it talks about this long-standing rule in Michigan that circumstantial evidence may be used to create reasonable inferences.
But Counsel, I want to make sure I understand what you think the record shows in your case, but I mean, we're not talking about uranium. There's some like, pollutants where maybe there are some things that lay people could understand. I think what the Chief Justice was saying was that, and what it sounds like your expert said, according to the literature, a gastric tear is incredibly rare and complicated. So, I mean, what lay people understand might be different than in other cases. Your case doesn't have to be, your case doesn't have to stand for all toxic tort cases. But tell me if I'm right. You had to show. Did you agree that you had to show that your client was exposed to VOCs at the relevant time to a relevant extent such that symptoms resulted? And do you think the record shows that?
I don't think that we necessarily have to show exposure to VOCs, although the...
You don't? Then why else would... How else is...
They have... my client was exposed to the heavy tar sands crude oil that comes with this noxious putrid odor, and I think there's plenty of testimony to that.
But odor's not a toxin. VOCs are a toxin. I mean, oil in and of itself, it's a compound. It's organic. You can swim in it. Those birds do, and they wash them off and set them free. It's the toxin that we're concerned about, right? That's what may or may not have caused the injury that you're here for.
I believe appellants would concede that the Enbridge oil spill, and they did concede in their brief, that there were VOCs released from the Enbridge oil spill. So that's not even an issue of fact.
All right, well, I don't want to spend too much time on it. I don't think they concede that there were sufficient VOCs on the relevant day in question or in the relevant place where your client was on the day when the vomiting that caused the rupture occurred. There may well be, I'm not sure they concede that the record shows that your client on that day was exposed to the sufficient level, but let's assume it does and move on to the where it gets a little bit trickier. It sounds to me like you both have to be able to show that exposure to VOCs at the amount your client was exposed to caused vomiting. You agree that would have to be something you'd show? That's one of the things that would result?
I would agree that we have to show that my client was exposed to the smell of the tar sands oil, which causes vomiting, nausea, and coughing. And I don't think that we need to show a specific
just the smell
amount.
of the oil, not a not the smell of the oil causes vomiting. Okay.
Well, I don't believe that we have to show that there was a sufficient amount of VOCs because we're looking at a unique circumstance. Every person has a unique set of sensitivity
Maybe
to
he
the
had
smell.
a cat.
I'm sorry?
Maybe he was allergic to cats or the smoke he was inhaling.
Well,
I mean, don't you, I mean, there are lots of reasons why people have symptoms. Don't you have to have a causal link to something specific here?
I mean, something about the oil spill had to cause this injury. Otherwise, you probably have to sue somebody else, right?
Or the
and
cat.
I agree that
Or something
the
else.
oil spill is what causes injuries. And
It's not oil spills. You have to show me a toxin. I mean,
Well,
oil is an
Counsel,
organic compound.
I have a question, Counsel. I realized he was taking this other medication. I realized he had these other things. Had he ever had any types of violent vomiting before the oil spill?
He did not. And
Had he ever
again,
had these types of symptoms to this extent before the oil spill?
he did not. And that's
The oil spill induced this type of vomiting, this type of thing.
yes, the oil spill does induce these type of symptoms. The chemical components, the chemical constituents of
But that's-
heavy crude oil.
You wouldn't acknowledge that when you were asked that by, what's your name?
Bridget.
I think that we have that here. What I'm not.
Well, why did you, I mean, you were acknowledging something that Justice McCormick was asking you.
Well, what I'm saying here is that there's not any dispute that the heavy crude oil contained these chemical constituents. And the evidence does show that those chemical constituents do cause these types of symptoms. But what I'm saying is that we don't have to show a specific level of exposure to VOCs. In this case,
Okay,
because,
I
I'm
think
sorry.
they might disagree with you on that, but I understand your position. You don't have to show it. It's enough to say he smelled it. But you do agree that you have to show that vomiting caused his tear, yes?
Yes, I agree that.
And you believe you showed that with the expert testimony that you provided. I just want to understand what burden you believe you did satisfy. Is that fair to
Correct.
say?
Yes, I believe that we provided a sufficient causal link based on circumstantial evidence with the
But with
testimony.
expert testimony?
With expert testimony, yes.
Okay.
And
Do you agree with counsel that they challenged the reliability of your expert to give that particular kind of testimony in the trial court? It wasn't in the trial court's ruling, so I apologize if I missed it. But do you agree with counsel that they challenged that?
I agree that they brought it up in their reply brief on their motion to summary disposition.
Well, I can look at both briefs, but counsel said both the opening brief and the reply brief.
And
Is that accurate?
I believe that they brought it up in their reply brief. And I believe in this case, we did not have sufficient opportunity to respond based on their arguments in the reply brief to those arguments. And I believe that if this court does believe that the testimony of Dr. Nosenchuk is at issue,
Reliability?
of questionable reliability, then this court should send it back to the trial court to hold a Daubert hearing. We definitely do not have a sufficient factual record to make the determination of Dr. Nosenchuk's reliability in this case. But notwithstanding that, Dr. Nosenchuk is a regular doctor, a family doctor. He is expected to know a little about a lot of things.
He said he's not an anatomist. He said he didn't know anything about toxicology. He is a general practitioner. He's a family doctor. And he's not a specialist. He doesn't know, he didn't testify he understood what the technical term is etiology, the study of what causes what in medicine.
I don't believe he testified that he doesn't have that specialized training. He is a family doctor, so he does have specialized training in diagnosing problems.
That occur in a general practice. He said he had no knowledge about toxicology, right?
That is true. He does not have knowledge about toxicology, Justice Young.
I'm locking you down now, so I think I am. There you go. No one can escape.
Well, counsel, he had knowledge about the vomiting, right? He had knowledge about the fact that the vomiting causes these types of injuries, correct?
That's correct, Justice Bernstein, and that's what I was going to get at.
Based on the two article abstracts, right?
Well, not,
He had no practice experience with this injury.
a family doctor would have experience.
He did not testify. I'm just trying to understand what he testified. He had no experiential exposure to a gastric artery resection, right?
That is correct,
Okay.
Justice Young, but
And wasn't his source of knowledge these two articles?
that is correct, Your
Okay.
Honor. And in his training, when he has no experience with these type of injuries, he would go to medical journals and those type of things and diagnosing problems. And if he's not specialized in that, he may be able to diagnose it and refer it out to another doctor for treating it. Dr. Koziarski himself had never seen this type of injury before, but that didn't preclude him from conducting the operation that saved Mr. Lowery's life.
But
Just-
isn't the critical point, once again, that these two articles were very clear that vomiting was a rare cause of what occurred in this case, and that an etiologist or somebody who had perhaps greater history and experience with that kind of analysis would have performed some kind of differential diagnosis that would have not only attempted to create a connection between the circumstances and the injury suffered here, but also to exclude other potential causes of that injury. That's what was not done here.
Well, a family doctor would be able to do that, and we don't have a factual record to support that conclusion that that was not done here, because we didn't have a Daubert hearing. But he did testify that he looked at the medical history of Mr. Lowery, and that it was more likely than not the avulsion was caused by this traumatic event of the coughing, the dry heaving, the nausea. And that was brought on by the Enbridge oil
Is it
spill.
relevant that he seemed to be uniquely susceptible to nausea, which I assume bears some kind of connection with vomiting? He was taking medication for that. He had a history of headaches and nausea. Does that possibly explain why in this total universe of people near the river, he was the only one who seems to have suffered from this particular injury?
Justice Markman, I think it is relevant because it would show that Mr. Lowery was more susceptible to this type of vomiting and coughing and wheezing bout that ultimately led to the avulsion. Mr. Lowery had previously had less severe symptoms, nausea and things like that. So he, in this case, would be an eggshell plaintiff. He was more susceptible to having this violent bout of vomiting because, you know, he smoked in the past. He did have some nausea associated with that. But, and what's in cigarette smoke? Tar. And then you expose him to tar sands crude oil, and then he has this violent fit of vomiting, coughing, and nausea that ultimately led to this avulsed artery. So it is relevant.
In your brief, you indicate it's not disputed that plaintiff appellee is required to prove both general and specific causation. However, Michigan law does not require that a plaintiff establish causation through direct expert testimony, and then you cite to Jenna. If we conclude that Jenna is being cited too broadly across the state for the proposition that experts are never needed in toxic tort cases, and we would like to limit Jenna, what help can you provide us in limiting that case?
Well, even if Jenna is overruled or limited, Jenna should apply when there is circumstantial evidence provided through expert testimony, because in Jenna, the doctor provided circumstantial evidence of causation. In this case also, we believe that we provided circumstantial evidence of causation. So if we want to limit it, where circumstantial evidence of causation may lead to a reasonable inference of causation, then we don't need direct expert testimony. In cases where there is a chronic illness, where direct expert testimony is more helpful in making the inferences, then we believe that direct expert testimony would be useful. But in this case, we don't believe that the direct expert testimony was necessary. Does that answer your question, Justice Zara?
I guess I'll have to ponder that. I'll think about that for a little bit. I'm not sure.
Anything else?
I have, well, I would say that if we go back to the Skinner case, which I was speaking of earlier, they cited to the case Schettelbauer, which is Schettelbauer versus Chris Kraft Corp. 381 Mich. 217. In that case, they also had an expert testify that a fuel pump leak would cause an engine to run rough. And then we had testimony that the plaintiff's boat was running rough and then it exploded. So there was enough there to establish a causal link, even though in that case the expert didn't testify that there was actually a leak of the fuel pump. There was enough circumstantial evidence to lead to an inference that there was a fuel pump leak. In that case, the boat exploded and the plaintiff was injured. And the plaintiff said that it was caused by a fuel pump leak. So he didn't have any direct expert testimony on that matter. And I would liken that to this case where we say that the avulsion would be caused by trauma or this violent bout of vomiting. So that would lead to an inference that the plaintiff's injuries were from the vomiting, which was from the oil spill.
Thank you.
Yeah.
Counsel, I'm trying to figure out, since the court ruled there was a lack of, the trial court, a lack of causation.
Essentially.
But it did so, I'm trying to figure out even if we were to agree, in general terms, there's some gaps here on the causation. What's the remedy here? Especially given that there was no Daubert hearing or anything else.
I think the remedy here is to reinstate the order of summary disposition from the trial court. We believe that the judge got the result right. The reasoning was wrong. Judge Kingsley, in another case, had held a Daubert hearing where two experts testified, actually a toxicologist and a medical doctor, on specific and general causation. In that case, it was about asthma and asthma-related symptoms. He concluded after the Daubert hearing that that plaintiff, who lived in a different area than Mr. Lowery, had sufficient evidence to move forward to a jury on whether exposure caused the asthma-like symptoms. Once he did that ruling, he then said, I can apply that ruling to every plaintiff who claims they had coughing or vomiting because I found it in this one Daubert hearing. We believe that was an error, to be able to say different plaintiff, different location, different exposure, different experts, but I can conclude it for everyone. So we think his reasoning that I can say vomiting was caused by exposure was wrong. The result, however, was correct, that there was no causation shown as to the rupture of the gastric artery.
What's the most fatal omission of required proof of causation in this record?
Well, because there is no evidence of any VOC exposure that was sufficient to cause any of the symptoms that are alleged here. You know, in oral argument, the appellee starts to talk about odor. This wasn't an odor case. On page 4 of their brief, they say this is a case about VOC exposure. And there's simply no evidence in the record that odor alone can cause the symptoms that they're alleging. Their own expert tried to say it was the benzene, xylene, toluene that resulted in these symptoms. The problem was he had no evidence of any exposure, let alone sufficient exposure.
That's the weakest part of their case, the general causation?
No, I think the biggest part of their case is the specific causation, whether he was...
I asked you what you thought the most fatal was, but you went to something you described as least fatal. Fatal, but not...
Well, I
What's the
think
most-
specific causation is, were they exposed to sufficient levels of a VOC to cause these specific injuries? That's specific causation in my mind.
Well, but counsel, but she said, though, that the VOCs were almost secondary. How do you respond to the fact that you have the incredible intensive odor, and it was the odor that came from the spill that's what induced the vomiting?
I understand, Justice Bernstein, that's their theory they're trying to advance on appeal. At the trial court, their theory was, and their evidence was, related to VOCs, not odor. They have no testimony on the record or no evidence on the record that odor alone caused these types of symptoms and resulted in the gastric artery. Their own expert tried to link it up to VOCs.
Anything else?
That's all I have, Your Honor.
Thank you very much.
Thank you.
The case is submitted.